courtrooms that you come into, when you come in, the galleries in the back, that's where the public can sit. And then there usually is a physical sort of fence or bar. And so that's where the term passing the bar comes from, because before there was a bar exam, people were apprentices of lawyers, and you were allowed to pass the bar from being part of the gallery to sit with the lawyers once your mentor determined that you were able to practice. And so before there were law schools, that's how it happened. So you'll come in and there's usually a gate, and inside that are where the lawyers sit. There's usually some sort of jury box, either on the right or the left-hand side. In district court, there's about 8 seats. In superior court, there'll be 14. There's usually a stand for the court officer to sit in, and on the other side, there's usually a place for the probation officer. And then you'll see a small bench where the clerk sits, and then the upper bench where the judge sits. In our courtroom, it's off to the side, but in most courtrooms, it looks like stepping stairs. And then there's usually either 2 or 4 tables in front of the judge, depending on how big the courtroom is. Traditionally, the party with the burden of proof sits closer to either the judge or the jury, but every courtroom is different, and sometimes it's just traditionally where people have always been since the beginning of time. So most courtrooms are set up like that, and I'm such a legal nerd that when I go on vacation, because my husband's a lawyer too, we'll go places and see what the courtrooms look like. So we were in Key West a little while ago, and so we went to look at the Key West courtrooms, and we actually met with a judge there, as they must have snuffed us out, because when she went, we stood up. And so the bailiff or the court officer came over, and we said, oh, we're lawyers from Massachusetts. And then my husband said, oh, my wife's a judge. And so we went in to speak with her. In Florida, I think the judges are elected, so it's a different situation. But it's just, I like to look at the different courtrooms, and they're all set up pretty much the same all over the country, which is kind of cool. The judge adjudicates the cases that come before them. The person who sits in front of them is a clerk, and you can either have a sessions clerk, an assistant clerk magistrate, or the clerk magistrate. Every courthouse has a clerk magistrate who's in charge of the clerk's office, and they're the people who essentially run the courthouse. So they take in all the paperwork, they're in charge of running the sessions, they are in charge of all of the scheduling, they're in charge of meeting with the public. All of the criminal complaints come through them, through the police department, all the civil filings come through them, all the motor vehicles come through them. They're sort of the heart of the courthouse. Also in the courthouse is the probation department. There's a chief probation officer, and then associate probation officers and assistant probation officers, and they run the probation department, which are people who are either on pretrial conditions of release or people who are placed on probation. They're really helpful to the judge just for their institutional knowledge, because a lot of times if I have a probationer who is suffering from a mental illness or a substance abuse disorder, and I'm trying to figure out what the best program is for them, they will be very helpful with their expertise about what they think I should do. Also on conditions of release, they run, if the person's on a GPS or a scram, which is a portable breathalyzer, they're in charge of all of that. The court officers are in charge of the security. Obviously, there's a chief court officer and then court officers who are underneath him or her. In this courthouse, it's Troy Boone, it's a male. They're in charge of lockup, they're in charge of the security at the door, and they're in charge of my security too. So that's another thing I didn't appreciate before I became a judge, but in this day and age, there is a lot of scrutiny on judges, and there have been threats of violence that I didn't really think that I would have to deal with. So there's a chain of command where if you get a threat, they report it to the local authorities, and then the police department in my town will come by in and out of my driveway and just check on me and things like that. So they're in charge of the courthouse security, the people in it, the people who are in custody, and then also the judge. The DA's office has an office in this building. That's not true for all courthouses, but they're the prosecutor's office. So they're a different branch of government. They're the executive branch, but they are in here mostly, I think, for ease of everyone, because cases come in and I sometimes need to pull them out of their office. But they have an office in here, they prepare their cases, and they argue in here, and then they'll go back to their office. Yeah, so Massachusetts is one of the states that has a bar advocate program that is designed to for anyone who cannot afford an attorney. And there's the Committee for Public Counsel Services, which is its own entity, but also you can be a bar advocate and be in private practice and also take those cases. So that's what I did before I became an assistant clerk magistrate. So that person's called the duty attorney, and they just sit in court, and anyone who wants an attorney who can't afford one, that they'll be appointed to them. So they'll do the bail argument that day, they'll do the probation, detention, hearing, and then once they have the case, then they defend that person from that moment up and until plea or trial. So they're paid by statute through taxpayers. And so they bill out, and there is a group that keeps track of what they're doing, and you have to tell them, oh, I prepped this trial for 2 hours today, and this is the case. And if they want to, they can call and ask you for proof for that, so that there isn't fraud or abuse in that system. And then you bill out monthly, and you get paid through that organization. That's a deep question. So we would be a completely chaotic society if we didn't have that. And we're lucky in this country because most people follow it. So most people who come into court are either jurors or they're here because they have some sort of speeding ticket. Because then, that can happen to anyone, and that's how they come in. And you'll get summons, and the people come and they follow the rules, and they sit here and they understand that there are ramifications to that. So, when you pull out of your driveway in the morning, you put your seatbelt on, your car is registered, it's insured, you have a valid driver's license, you look both ways, you don't go through red lights, all of that because you as a person have been ingrained in our society that these are the rules and this is how you follow them, and you get in trouble if you don't. If we did not have that, it would just be mass chaos. And I think that's some of people's concerns about what's happening in our country now with people who there seems to be a discussion about where we get our information from, what we believe. Is there a set of facts that we can all agree on and then use that in order to do what we want to do with our lives, how we want to conduct elections, how we want to be governed. So that it's an interesting situation now to see some people don't trust the rule of law, which I think is a shame. The good thing for us in the district court is after I speak with jurors everyone sort of comes here wanting to get out of jury duty. But after they have it, they come in and they really feel like, wow, the system works. Everybody got a fair shake. People were held to their burden of proof. I saw the police officers testify. I saw the defense attorney be able to cross-examine people. I was able to listen to the evidence, and here's the decision we made. I think a lot of people leave district court feeling satisfied that our system of justice works. It obviously doesn't work for everyone, and it's not fair, and there are disparities with respect to people's race or income or national origin, and the district court is really striving to make this a platform for equal justice for all, and that's coming from the top down, from the Chief Justice of the trial court through the SJC, which is our Supreme Judicial Court. There's been a lot of studies lately on race and fairness and how people are treated when they're initially arrested or pulled over, and how they get, once they get into court, how they're treated. And Massachusetts is sort of a leader in trying to make sure that people are treated fairly and that people respect the rule of law. So we're doing the best we can. It's getting a little tricky lately, but it doesn't mean that you just throw up your hands and say, there isn't anything we can do about it. You got to put your head down and come into work every day and apply the law, the facts, and be as fair as you can be. So that's a good question too, and the coronavirus has really sort of thrown that into a loop. When I first started practicing, there were a lot of older judges on the bench who would send people home if they weren't dressed appropriately for court. That doesn't bother me as much because I don't know if somebody who's before me has nice clothes. Some people who come to court in the criminal justice system, can barely get out the door to the day. They're just trying to do the best they can. I'm just glad that they're here, so that doesn't bother me. It does bother some judges, especially judges in a different generation than I am. I also allow cell phones in the courtroom. Some judges don't do that because they don't like people on their cell phones. I actually find that it keeps them quieter and they're not talking and disrupting, and so I can't hear, so it doesn't really matter to me what they're doing. People who are disruptive or who are outwardly rude to me, it's a fine line between sort of getting them to calm down. You can either de-escalate the situation or escalate the situation. I try to de-escalate. And then sometimes, I'll give them a warning. I'll tell them, if they speak out again, I'll remove them from the courtroom. If they're disrupting a procedure or being outwardly abusive to me or someone else in the courtroom, I can fine them in summary contempt and take them into custody. And then there's a hearing about whether or not there's a fine. But during COVID, we had so many things on Zoom that people started coming into court for their court appearance and they'd be in bed or in their jammies or in the bathroom. I had a gentleman who was a barber who was cutting someone's hair. I've had people out walking their dogs. I've had people who are driving. So it was very stressful at the beginning to have to say to every person, and eventually I had a little speech prepared to let people know you're still in court, you need to act like you're in court, and it sort of has led to people not taking it seriously. So I'm glad that we're open again, because I think being in court and seeing the judge on the bench and the lawyers are in their suits and everyone's sort of on their best behavior was better. But for a while there was a complete societal breakdown about what was appropriate behavior and what wasn't. And I found that to be very stressful. It was really another layer of something I had to contend with before I got to what my job actually is. So that was hard for me when I first got on the bench because I'm a woman, and at that point I was the youngest judge in the state, and especially some older male attorneys were very disrespectful to me, and it's a fine line between sort of taking it personally, making a decision about whether or not they're being disrespectful of the court or just me as a person, and the best way to deal with that. So that's sort of been a learning curve for me on when to engage and when to just get what I like to call selective hearing. So. So that's an open question now that is decided many, many ranks above where I am. From a personal standpoint, I don't mind it. It's easier for lawyers who have cases on in multiple courts, then they can just zoom in and zoom out. It's less commuting time. I also recognize that everyone's a human being. A lot of people have children or elderly relatives they're taking care of or other things they need to go on in their lives, and all the preliminary matters that go up into something substantive. So just the pretrials or compliance and election, I don't care if they pop on and they're just getting a date. Also for the people who are in custody, it's a lot easier for the court officers here not to have as many bodies downstairs, because the more people you have, the more instance there could be for some sort of altercation. Also, they have to wait for the transportation to come from the different houses of correction to drop the people off and pick them up, so it's sort of logistical nightmare, and it's more expensive for the state, whereas they just have to pop on the camera. And again, for those preliminary things, I don't mind it at all. We also have some people who live in other states, and they may have moved and are coming back in for a restraining order hearing, or they have some sort of motor vehicle case here that's not that big a deal that they forgot about. Maybe they forgot to pay a fine. Their license got suspended here. They're trying to get their license now that they moved to New Mexico, and the New Mexico Registry of Motor Vehicles pops up that they have this thing they have to take care of in Massachusetts. Now, for a $25 fine, it doesn't make sense for that person to get on the plane and come here and do all that. So that has made it easier. Yeah. The thing that I find the most frustrating about it is when the interpreters are on the Zoom, because the people are in court responding to one another and they forget and they're trying to interpret. And so if you have, I had one restraining order, which afterwards I had to get off the bench and take some time because the plaintiff needed a Spanish interpreter and the defendant needed a Portuguese interpreter, and then there were a lawyer for each party and me and the two interpreters. So I would ask a question, the Portuguese interpreter would have to say it, the Spanish interpreter would have to say it, the person would answer me, and then we would go around and around, and the hearing would get a little bit heated and people would forget and talk over each other, so you have to have the timeout. And that doesn't happen when the interpreter's in court, because they do simultaneously translating. So a lot of them are able to give the person who needs an interpreter earphones, and then they're just talking into a next, so they're just saying everything that's saying, and so the hearing is conducted as if we're all speaking English. Or the person is next to them sort of whispering in their ear. So I hate the interpreters being on Zoom, but the problem is during the pandemic, we've lost a lot of interpreters, and the population in Marlborough needs a lot of Portuguese and Spanish interpreters. So we spend a lot of time waiting for interpreters to come in, and they're mostly on Zoom. So I'm grateful when they do come in on Zoom, but it's difficult. The other thing that is hard is if a person elects a trial on Zoom. So we don't have jury trials on Zoom, but we do have bench trials in front of a judge. That's difficult because it's hard for them to speak with their attorney. So you have to put them in a breakout room and then come back on. And so the logistics of that I don't like. But for default removals or one-party hearings that don't need interpreters or just people getting dates, I wouldn't mind if that stayed, but I don't know what the outcome is going to be. That's a really good question. So in district court, we're in Middlesex County, so they're picked from the county. So as long as you are of age, which is 18 to 70, you are eligible for jury duty. So you get a notice in the mail. I actually have jury duty March 23rd, I think, over in Woburn. You get a summons in the mail. You get a right to move it at least once for no reason. And they tell you to come here. So you show up at 8:30, you go into the jury pool room and you just hang out. You get to watch a little video about the jury system. Then I go in and greet them in the morning and sort of tell them what's gonna happen. If the case is ready for trial and we're ready for the jurors, they come in all together and they're called the jury veneer. At that point, a series of questions are put to them by me, asking whether or not they understand that the Commonwealth bears the burden of proof, that a person is presumed to be innocent, that they don't have to testify, and then questions about whether or not people have any bias, either toward the prosecution or against the defendant, or the other way around, and whether or not they would have any issue with the race of the defendant, the origin of the defendant, the religion of the defendant, anything like that. And then after those are the statutory questions that are asked. If people raise their hand, I mark their numbers, their jury numbers, down on a piece of paper. Then I bring the defense attorney and the prosecutor up, and then we do it one at a time at sidebar. So I bring them up, juror number one and seat number one, they come up. I ask them if they heard and understood all the questions that I asked, and if they answered them honestly. And I always ask those because when I was a prosecutor, I had a jury trial where the judge did it the old school way, which is just ask everyone the questions. If no one has any questions, the first 6 people get on the panel. And one of the women did not speak any English at all. She only spoke Chinese, so she didn't answer any of the questions because she didn't have anything to say. And so I learned from the court officers after that she didn't participate at all in the verdict because she didn't understand. And I also, as a former trial attorney on both sides, you kind of like to get a closer look at the juror and see what they say. Then I usually ask them, when hearing testimony from police officers, would you tend to believe a police officer over a civilian witness just because that witness is a police officer, or would you give the testimony equal weight? And it's also really interesting because sort of people who are over the age of 50, a lot of times they'll say they'll believe the police officer. If I have jurors that are under the age of 25, they'll often say that they wouldn't believe the police officer, which I think is an interesting generational change that we've had in this country based on what's going on in the country with law enforcement and the fact that people have cell phones on them now. So I usually excuse people who answer the question either way because I want to make sure that the juror is as fair and impartial as they can be, and that their only role as a juror is to listen to the facts as they come in this case without bringing any outside influences, apply the law as I give it to them, and render a true and just verdict based on just what happens in the courtroom. So after they've answered those questions of mine, if there are particular questions on a case, so a lot of times in a drunk driving case or an OUI case, I tell them that it's not a crime crime in Massachusetts to consume alcohol and then drive. The conduct becomes criminal when a person has consumed enough alcohol such that their ability to operate the motor vehicle safely is impaired by alcohol, because that's the law. So a lot of people who come in think if you have one beer at dinner with your family and get in the car, you're guilty of it. That's not true. So I like to make sure that people understand that. After we're done asking those questions, they go near the jury box, and then I ask the prosecutor if they're content. If there's anything on the juror form that you fill out beforehand, some people say, oh, my brother was convicted of a crime, whenever I can't be fair, or something like that. I'll bring the person back and ask them. The defense attorney may have some questions about the way they answered questions. So I'll ask any questions the attorneys want to until they feel comfortable with that person. They can either exercise what's called a peremptory challenge, which means they want to challenge them and they don't have to tell me why, or a challenge for cause, which is where they tell me why. You can have as many challenges for cause as you want to, but you only get 2 peremptory challenges in district court. And then the people are seated, and that's how the jury's picked. In my personal opinion, I think that we should get rid of peremptory challenges, because usually somebody's making a peremptory challenge because they think the person has a bias. And then that's where you get into the situations where people are getting excluded from jurors because of their race or the race of the defendant, or because they're a woman, or any of those other sort of immutable characteristics. I think you should have to challenge for cause, but I'm not the one that makes those rules, so I gotta stick with the way they are now. So that's a good question. Civil cases are people who are essentially fighting about money. So it could be, a contractor put a pool in your backyard and didn't do a good job, so you're suing them because you want some money back for the money you paid for the pool. It could be you own a supermarket and someone slipped and fell in the frozen food aisle and they want money for their injuries. It could be there was a car accident, people got injured, so they want money for their medical bills, things like that. So you're only fighting about money in a civil case. There's no jail time. Criminal cases, there are either monetary penalties or penalties up until a jail time with probation in between. So the district court has jurisdiction over any misdemeanor and any felony whose maximum penalty is 2.5 years in the House of Correction or 5 years in state prison, and the civil cases are amount in controversy up until $75,000. So that's also a good question and can be tricky. So what I do first is I look at the nature of the crime. So if it's shoplifting, that's not as big a deal as killing someone with your car. Then I look at the person's criminal record. If they don't have a criminal history, sentencing is successive. So if it's shoplifting, I might just give them a fine. The maximum penalty is a fine. It might be dismissed on court costs, or they just get a fine. The next portion of sentencing is what's called a continuation without a finding, which is what most people get on their first drunk driving or their first OUI. What that means is that they're on probation for a year, but after the year, if they don't pick up new criminal conduct and they do their conditions of probation, which on an OUI would be to attend the 24D program, which is an alcohol education program, the case gets dismissed. So if you look at their record, it says continuation without a finding, and then it's dismissed. After you've had some quaffs, you go to the conviction, you get guilty probation, which is straight probation. There's a conviction on your record, but you do the programs, and when that's over with, there isn't any other criminal liability. After guilty probation, you move to a suspended sentence, which is instead of just straight probation, the suspended sentence is hanging over your head. So if you violate it, you immediately go to jail. If after that you get a split, so you might get 6 months in the house with the balance suspended, so then you're on probation. If you violate that again, then you get the portion of the sentence is triggered, and then after that it's jail time. So it depends on the nature of the crime, your criminal history. Also in Massachusetts, if you are a victim of a crime, you have a right to be heard at the sentencing to let the court know how the crime affected you and what you want to see happen. And then I have to balance the punishment with the rehabilitation. So if the impetus for their criminal activity was a mental health issue or a substance abuse issue, we try to mitigate that and see if we can get them some help while they're on probation so they don't come back. If it's somebody who is just committing crimes over and over again, at that point I'll just send them to jail. So in the criminal context, the first appearance is called the arraignment date. That is when the person is given their Sixth Amendment right to an attorney. So if they can't afford one, we'll appoint one. Sometimes they want to hire one, sometimes they want to waive it. They're entitled to know what the charges are against them, which is the arraignment gives the name. When you hear the clerk saying, you know, on such and such date, you're charged with this out of whatever the city is, that's their knowledge of what they're accused of. Then I determine whether or not they need an attorney, and then I determine if the Commonwealth is asking for bail in conditions or monetary bail, and then we have a bail hearing. The next time the case comes back is called the pretrial conference, where the attorneys get together and exchange what's called discovery. So in district court, it's usually just the police report, or if there's a 911 call, or something from the registry of motor vehicles. If it's a motor vehicle case, they turn that over to the defense attorney, and the defense attorney then asks for what's called a compliance and election date. So they take that information, ideally they go back and have a conversation with their client about the strengths and weaknesses of the case. They look at the client's record, they think about whether or not they want to have a trial or if they want to resolve it. They come back on the compliance and election date, and that's when it gets a little tricky, because you get some people who want 5 more compliance dates for no reason. You get other people who are saying, I think it's going to be a plea, we'll put it down for a plea date. There are other people at that moment who know that it's going to be a trial. If they know that they want a bench trial because it's just a legal issue, or they think people aren't going to show up, they'll put it down for a bench trial. And so once you're at the compliance and election date, you're either moving toward pleading the case out or choosing a trial in front of a judge or a trial in front of a jury. In a civil case, they file the complaint, and then it's a lot of behind the scenes between the lawyers about starting the depositions and doing their discovery. So the judge sort of pops in just to make sure that they're not languishing and not doing anything. So they have something called the case management conference. That's the first date. It's similar to the pretrial hearing in the criminal. What are you doing? What's going on with the case? Oh, we haven't started depositions yet. Okay, do you need another case management conference? So after the case management conference, then they have a pretrial hearing. In this court, I make people go to conciliation or mediation, just because I think it focuses the mind. A lot of civil cases will just put something down for a jury trial, and then they'll come in and we'll have the jurors waiting, and they'll be taking up a jury slot, and then that's the day that they decide to settle, which to me is not a good use of judicial resources. If you're going to settle the case, you know, let's not drag 6 citizens of Middlesex County down with us, because I have this whole criminal docket waiting. So if you're going to have a civil trial, I'm happy to hear you on a civil trial, but let it actually be a trial. So they go to mediation, then they come back. And then if they're ready for pretrial, I take them through a series of questions about whether or not they've have a statement of the case, if they have their verdict slip ready, how many witnesses are they going to have, how long does they think it's going to take, do they have the jury instructions, are they ready for voir dire, all that kind of thing. And again, sometimes with the civil lawyers, that will also cause me to realize that they're actually not ready for trial and that they need more time. So I more play sort of an umpire role there, and I kind of feel my daughter sometimes when she sits in court, she's like, oh, the mom voice came out, because I get frustrated when it's clear to me that people haven't done their homework, and then they're in here telling me that they want to do something which is going to take a lot of time and resources, an entire courtroom. I have to get another judge in here, and they're not ready. So that's sort of, I'm trying to herd some cats there since I've become the first justice, because the civil list was sort of like the Wild West, and so we're trying to move that together. So that's the different tracks that we go on. So that's a conversation between the prosecutor, who is the person who is trying to convict the person, with the defense attorney, who's trying to protect the rights of the person who's charged with a crime. It's the conversation they have about what's going to happen with the case. So if you're a middle schooler, it would be like if you were going to your parents and you were trying to get, Instagram for your phone, and you were going to give them reasons why you thought Instagram was great, and they were going to give you reasons why maybe not so much with the Instagram yet, but you can have texting capabilities. It's a conversation between the parties sort of bargaining about whose position should win out. So sometimes none and sometimes a lot. So the Commonwealth sort of holds all the cards there because they're the moving party. And so the defense attorney can go to the DA's office and say, one of a number of things. If it's a more serious charge and it's a felony, they might ask them to what's called break the case down to a misdemeanor and then plead out to a misdemeanor. And the reason for that is it can save somebody's criminal history, because a lot of times when you go for a job, they'll ask if you've been convicted of a felony, but they won't say anything about a misdemeanor. So the collateral consequences for someone are worse if you have felonies on your record than if you have misdemeanors on your record. So they might ask for that. The DA's office might say, okay, bring me some information, because if you say my client has mental health issues, they're treating for this particular thing with this person, oh, just get me a letter from the doctor saying that and we'll try to work it out. So they have conversations between themselves. If they want to plead out, and in district court we have what's called a defense cap plea. So if the defendant doesn't like what I'm going to do, they can withdraw the plea. So a lot of times they'll come to me in what's called a lobby conference, and the name of that is, you used to, especially when I was a new lawyer, you would go back and sit in the judge's office and just chat about the case off the record. You're not allowed to do that anymore. It has to be on the record. So they'll come to the sidebar, I'll put the white noise on so other people can't hear, and it's opportunity for the DAs to tell me about their case, and at that point they're honest about what the strengths and weaknesses of their case are, why they're asking for what they're asking for. I ask a lot of questions about what the victim thinks, and it's an opportunity that I appreciated when I was a prosecutor. If I wanted to tell the judge, listen, like, this case, when it comes to trial, is not going to be as strong as it is now. So I am interested in giving the defendant a better deal than to put this in front of a jury. And then the defense attorney will come and say, I understand why the Commonwealth's asking what they're asking for, but these are all the programs my client's in. She's a mom, she has these kids, she's working with DCF, she's trying to get her GED. These are all the things, and it would be detrimental to her if she got that sentence. So please sentence her to whatever I'm asking for. So then I'll look at the record. Like I said before, I'll look at the charges, I'll look at the underlying, I'll take the consideration in of what the victim is, and I'll do my best to balance the punishment and the rehabilitation, and then I'll tell them what I'm going to do. And they go back and take that to the defendant, their client, and say, this is what the judge said she's going to do. If you take it, this will happen. If you don't take it, we can go to trial, and they'll have that conversation. So then we'll end up putting the case down for disposition. There are different kinds of warrants, and so it's different. If you want a search warrant, the standard is probable cause to believe that the things that you're looking for are going to be in the place that you say they're going to be. So, for example, if you want a search warrant for a person's apartment and you think that they're a drug dealer, you would have police officers watching that person, and you would have confidential informants that would tell you that they use this person as their drug dealer, and they go to this apartment, and this is what the apartment looks like, and inside you'll find this, and this is what you're going to find. So then the police officer signs an affidavit, which is a piece of paper saying that they're telling the truth about everything in there, and then a judge or an assistant clerk magistrate would read that and think if there's probable cause to believe that's true, that those items are going to be in there. If you are issuing a warrant for someone's arrest, that usually isn't a judge except in certain situations. So if the police are looking for an arrest warrant, they go ask the clerk magistrate. And again, it's probable cause to believe that the person committed the crime. So they just need to outline what the elements of the crime are. And so by that, it's like baking. So if you want to make a cake, you need eggs and butter and flour and sugar. And if you don't have one of those, then you're not going to get a cake. So if you're missing one of the elements of the crime, then you're not going to be able to prove the case at trial or get a warrant for the person. The warrants that I mostly issue in court that you probably saw were probation warrants or warrants when people didn't show up. So if the probation department is seeking a warrant, they just have to display to me that the person is in violation of one of their conditions. So most likely if somebody's on a GPS and the signal went off, they either left their house if they were on lockdown or they went into the exclusion zone they weren't supposed to be, a beacon goes off and alerts them, that's a violation, and a warrant issues immediately to pick that person up. Because the reason why they're on GPS is because some judge found them to be so dangerous that they either have to stay away from the person that they are alleged to have harmed, or they're a danger to society, so they need to be in their home. If they're not, you issue a warrant immediately to get them into custody and figure out what happened. I issue warrants on a regular basis in court for people who don't show up. So if you can't, it's not like a birthday party. You don't get to decide if you're coming or not coming, and it's not an open house, so you can't come whenever you want. Court's at 8:30 in the morning. You need to come to court if you don't have a reason or you haven't called your attorney. a warrant's going to issue for your arrest. And the warrant goes into a computer system, so it's actually kind of cool where if you get pulled over for speeding, they'll take your license and do a warrant check. If you have outstanding warrants, you're getting pulled out of the car, you're getting arrested, you're getting put back in the car, and your car is getting towed, and you come in through the lockup and you see me, and my question is, where were you? So those are the different kind of warrants that get issued.